Hi, welcome everybody to this lecture on national security law in Hong Kong 1 year on. We are absolutely delighted to have Professor Johannes Chan, former Chair of Public Law and Dean of the Faculty of Law at the University of Hong Kong, one of the longest serving deans in the faculty, a hugely distinguished academic and also senior practitioner. Johannes retired from University of Hong Kong in July 2021 and is currently an adjunct professor at the University of Hong Kong and a visiting professor at UCL. Johannes, on a personal note, Johannes is an old friend of mine. We used to have a dean support group, which I remember well. And we devised together a double degree between Hong Kong University and UCL, double degree LLB, which we still continue. So Johannes is very well known at UCL and in many other universities around the world. In terms of his academic work, he specialized in human rights, constitutional and administrative law, and has published widely in those fields and lectures regularly around the world. So Johannes is going to give his lecture, and after his lecture, we're going to have some comments from Professor Jeff King, who's a Professor of Law in the Faculty of Laws at UCL. He's also Principal Investigator of Lex Atlas COVID-19 project and is a former legal advisor of the House of Lords Constitution Committee. He's also has a long-standing interest in China and has worked at worked with University of Hong Kong and in Renmin. And actually, one of the things I should say also about my relationship with Johannes is that we organized a couple of very successful workshops in Beijing on human rights in previous years. So we share lots of interest in common. Anyway, I don't want to take up too much time because Johannes has a lot to say. This is a matter of great interest to people within the faculty, within the university, and in the UK in general. And so, Johannes, I think it's over to you now to give us your lecture on national security law in Hong Kong 1 year on. Thank you.
Right. Thank you, Hazel, for the very generous introduction and for chairing the sessions. And thanks also to the Dean of the Faculty of Law at UCL for inviting me to give this lecture. And it is my special honor and privilege to have my good friends, Hazel and Jeff, to join me this evening. And it has been 18 months indeed since the NSL has come into effect. And my research interest is primarily about the judiciary. So the first part of my lecture tonight will be a brief introduction of the provisions of the national security law, and followed by an examination of how the judiciary has responded to the NSL. And towards the end, hopefully to make some reflection on the possible role of the judiciary in a harsh regime. There are both long-term and short-term immediate factors that led to the enactment of the NSL. Suffice to say that the immediate triggering effect is the Extradition Bill in 2019. The bill allows or proposed to have extraditions between the mainland and Taiwan, but then it extends to arrangement between mainland and Hong Kong. That immediately aroused widespread concern for the destructions of the only firewall between the two legal systems. The government insists on proceeding with the bill, despite 1 million people took to the street in opposition. And the legislative process was halted only when some protesters stormed into the Electrical Building on the day of the second reading. And this became a turning point in Hong Kong history, which was followed by a period of civil unrest in the latter part of 2019. And they set the scene for the NSL, which was drafted and adopted by the Standing Committee of the National People's Congress without any substantive or public consultation of the people of Hong Kong. Indeed, NSL was published only when it came into effect on 30th of June 2020. The apparent aim is to restore law and order and to protect national security. It was said at the time that only a small minority of the people will be affected. But it goes much further than that. A closer analysis of the provisions shows that there are at least 3 different objectives. The first is, as said, it affirms inviolability of sovereignty and territorial integrity. And this is achieved by introducing broad and sweeping national security offenses. The second is that despite the constitutional promise of a high degree of autonomy, the central government is keen to assert full jurisdiction over Hong Kong. And this is achieved by providing for a formal role of mainland institutions and personnel in the governance of Hong Kong. And the third objective is more subtle, and it is to contain the judiciary by curbing judicial powers and discretions, which in turn reflects the central government's dissatisfaction and skepticism about judicial independence in Hong Kong. 3 short preliminary points. The first is that the power of final interpretation of the NSL is vested in the Standing Committee of the NPC, and it prevails over any inconsistent local law. But then Article 4 and 5 of the NSL does provide for the protection of fundamental rights in the basic law and in the international treaty, International Covenant on Civil and Political Rights, including the presumption of innocence. Now, if you look at the first objective, affirming sovereignty, a number of vague and substantive offenses were introduced, including secession, subversion, terrorist act, and colluding with foreign forces. And apart from these 4 main offenses, the NSL introduced also various inchoate offenses, which is supported along the common law, like the offense of incitement and conspiracy to commit these offenses. The offense of incitement is particularly noteworthy because the substantive offense of secession and subversion could be committed without any force. It expresses the state to be whether by force or otherwise. So it could be committed as by words. And an incitement to commit this offense will effectively create a verbal offense to commit another verbal offense without any actions. And alongside these NSL offenses, there are, of course, also the political offenses in the Crimes Ordinance, which exists since the colonial times, and including the vague and sweeping seditious publication offenses. There are also other public order offenses like unlawful assembly and riot, and even money laundering offenses have been invoked. On the second objective, various institutions has been set up, including a Committee for Safeguarding National Security, the NSC. This is a policy-making body which has wide-ranging power, chaired by the Chief Executive. But among the members include a National Security Advisor, who is the head of the Chinese Liaison Office in Hong Kong. And this is for the first time a PRC senior officials are given a formal role in the policy-making process of the Hong Kong Special Administrative Region. There is then also the National Office, the Office of Safeguarding National Security. This is the NSO. This is a mainland office staffed by mainlanders, mainland officials. And its roles include conducting surveillance, advising the Hong Kong government, overseeing and guiding the Hong Kong governments in matters regarding national security, which are extremely broad. And an alarming aspect is that it has power to remove a suspect from Hong Kong jurisdiction to face trial in the mainland. There are also special units within the police force which has been set up, and the head of the police force unit is appointed upon the advice of this NSO. Also, a special prosecution unit was set up within the Department of Justice. Again, the head was appointed with the advice of the NSO, and even prosecutors of this unit was appointed with consent of the NSC, the committee. And glaring feature is that the Director of Public Prosecution is not involved in the special prosecution unit, and it is this unit that is responsible for deciding whether and on what offenses that would the committee be charged, or would an offense be charged. The suspicions of the judicial independence of the judiciary and is largely more subtle, and this brings me to the long-term factor leading to the enactment of the NSL. Since 1997, the Hong Kong courts have established an international reputation of being a leading global model of common law constitutionalism in action. It has established an impressive body of liberal constitutional common law within a short period of time. And the democratic deficit in Hong Kong led to an increasing number of challenges in court of the constitutionality of executive policies or legislative acts, and this has been done with some success. This has raised the eyebrows of the central government, and political discourse in recent years has gradually changed from checks and balances to mutual support of the three branches of the governments. There is a denial and rejection of the doctrine of separation of powers and replace it by a separation of functions under an executive-led government by the chief executive. And if we just look at some of the recent speeches of various central government's officials, and we can discern that separation of power plays a very different role in a democracy and in an authoritarian regime. In a full democracy, the doctrine of separation of power serves the function of fine-tuning the system by checking against arbitrary exercise of power and to refine the balance between the majority and the minority. Whereas separation of power in an authoritarian regime plays a very different role. The whole idea of sharing of power and checking the power of the ruling regime is politically unnerving, potentially revolutionary, and by nature alarming, if not also seditious and treacherous. The government, both PRC and Hong Kong, has consistently rejected doctrine of separation of powers, even that has been affirmed by our court on a number of occasions. And interestingly, in 2017, the chairman of the NPC Standing Committee said the political system in Hong Kong is neither executive, legislative-led nor judiciary-led. This is a strange word to refer to judiciary-led in describing a political system. And the chief executive in 2020 said the system in Hong Kong is not one of separation of power, but separation of functions. And in 2021, the Honorable Tam Yu Chung, who is the only Hong Kong member on the NPC Standing Committee, said the Hong Kong court should pay greater respect to the power of the central government. It should not arbitrarily create new law, adopt an elitist attitude in discharging its duties, and excessively inflate its power and its role, which is quite telling of what the central government is thinking about the Hong Kong court's role in Hong Kong. And then more recently, the director of NSO said the judicial power is one of delegates' power, and the Hong Kong judiciary should thus highly manifest the national will and national interest, or else it would lose the legal premises of the authorizations. This is by far the strongest comment on the judiciary in Hong Kong. So one can discern that kind of distrust in various provisions, and I try to gather them into three categories. First category are the general directives, and second categories are provisions which restrict judicial discretion. And the third categories are provisions which just simply oust the jurisdictions of the court. On the first category, these are general provisions which provides for the duty of the judiciary to prevent, suppress, and punish acts and activities endangering national security, and the duty to enforce the NSL. To a common law lawyer, these seems to be stating the obvious. The role of the court must be to enforce the law, and what else? But in the mainland tradition, the general directive serves as setting the tone for the interpretation of the law. And the tone seems to engage a strict and harsh approach to interpret the law and imposing a sentence, and which has been the case. And indeed, our court has made use of some of these provisions to conclude that there could be no inconsistency between the NSL and the basic law, meaning that it would exclude any attempt to challenge NSL offenses on the ground of unconstitutionality or incompatibility with the fundamental rights provisions in the basic law. There's a whole group of provisions which try to restrict judicial discretions, and I'll discuss in more detail some of these provisions relating to the granting of bail, to a trial without jury, and even certificate of acts involving national security. Some of these provisions go to the heart of the criminal justice system. And finally, the last group of provisions outs the jurisdiction of court altogether. The NSC, the policy-making body, there's no jurisdiction over its decisions, and its decisions are not subject to disclosure. The NSO, this is the national body, while their staff are required to abide by the laws of Hong Kong court has no jurisdictions over the act of those staffs. And I've already mentioned the NSO has power to remove someone from the jurisdiction of Hong Kong under certain circumstances. And this power is exercisable upon approval of the central government. And once invoked, a person could be removed out of the jurisdiction without even the safeguards of independent judicial scrutiny that exists in ordinary extradition process. And the persons will effectively be under Chinese jurisdiction, tried by Chinese criminal law. Another alarming aspect of the NSL is it allows the chief executive to designate NSL judges. That means only NSL judges can try NSL cases. The designation could be made after consulting the National Security Committee and the Chief Justice. The designation is for 1 year only, subject to renewal, and there is power to remove from the designation at any time if a designated judge has made any statement or behave in any manner endangering national security. And this is a rather vague phrase, and whether it includes a judgment that the government does not like. And in contrast with designation, the de-designation or removal of designation, there's no explicit duty to consult the Chief Justice. There's also no public announcement about which judge has been designated or about their removal. And the chief executive justify this power on the ground that this is no difference from specialization in the court. Currently, our court has a specialized commercial list, family law list, constitution administrative law list. So this is just another list to allow specialization. And the power to assign judges in a particular case it still rests with the Chief Justice or the Chief Judge of that level of court. The designated judge system has been challenged in the first NSL case, the Tong Yin Kit case. A divisional bench rejected designation of judges as an inroad to judicial independence. The court accepts the government's justification that it confers general power only, and the power to assign judges in any particular case is still vested in the judiciary. While this is true, whether the judiciary has any discretionary power, one depends on how many judges have been designated. And in some courts, there's only one judge which has been designated. And in any event, even if there's more than one judge, the judicial discretion is limited to the designated judges only. The court said also that the power does not affect the tenure of a judge who is bound by judicial oath. And insofar as the prospect of not being designated again, the court said implicit in this argument is that it is somehow advantageous or beneficial for a judge to be designated to handle national security cases. This is completely unfounded. This is laudable that the trial judge adopt this admirable attitude, and it is probably true regarding judges at a higher level of court. But the effect of removal from designation on promotion at the lower level of judges, particularly magistrate, would still be a major concern. And in any event, it doesn't answer the more fundamental questions. Why should there be such a power in the first place and to be exercised by the chief executive? And why should the discretion of the judiciary be fettered? And why create a list of government-approved judges? And what are the criteria for the designation? Would it serve to exclude certain judges who may be regarded as too independent or overseas judges, which is still unclear at the moment whether the overseas judges would be allowed to try any national security cases? And could the removal of designation by the chief executive becomes a summary process to punish or discipline non-compliant judges? these questions remained unanswered. Now, if we turn to the bail applications, Article 42 said that no bail should be granted to a criminal suspect unless the judge has sufficient grounds to believe the criminal suspect will not continue to commit acts endangering national security. Note that it is framed in double negative. And I've already referred to Article 4 and Article 5, which expressly protect human rights and freedoms under the basic law and the presumption of innocence. So obviously, these provisions have to be considered together in construing Article 42. In the first NSL case, Tong Yin Kit, he was denied bail and he applied for habeas corpus and a review of the decisions of the magistrate denying bail. And the case was heard by a divisional bench of the Court of First Instance of the High Court. The divisional bench decided that the NSL has to be construed consistently with the basic law and Article 4 and 5 of the NSL. It affirmed the principle that the court should give a generous interpretation and has a duty to protect fundamental rights. It also asserts that the common law approach should be adopted in construing the NSL. And on this basis, the divisional bench conclude that Article 42 does not really change the existing principles on bail. The court said that notwithstanding the double negative formulation, when considering the question of bail, the question for the court is whether there are grounds to believe that the accused person will continue to commit acts endangering national security. And acts endangering national security are confined to offenses under the NSL, because this is provided by the NSL and not any other acts which may be said to endanger national security. Regarding Article 42, the divisional bench held that the effect is to make the likelihood of committing NSL offense a mandatory factor that the court must consider in bail application, which in any event would be a relevant factor in any bail application. And it concluded, in short, while there may be a difference of emphasis between the Criminal Procedure Ordinance and Article 42, the impact of Article 42 is more apparent than real. The practical application of Article 42 is unlikely to result in any different outcome of a bail application in the vast majority of cases. And it should not even be read as imposing a presumption against bail. This is a celebrate judgments typical how a common law judge would be able to contain the drastic effects of an apparently drastic provisions. After the judgment, the court was personally attacked by the pro-establishment media, and eventually the decision was reversed by the Court of Final Appeal in the Jimmy Lai case, which I'll come to now. Jimmy Lai, the gentleman on the top corner, he is a prominent businessman, a media tycoon. He's the founder of the newspaper Apple Daily and Apple Group, and he's a fervent supporter for democracy. And he was charged with two offenses. The first is collusion with a foreign country or foreign elements to endanger national security. And the evidence consists primarily at the time is various interviews with US correspondents. And the second charge is a fraud charge for violating a condition in the relevant land user, primarily by allowing a secretariat company to unlawfully use the premises that he rents from government, which represent only 50 square meters, less than 0.1% of the land. It's more like a civil matter inflated into criminal matter. And on the bail application, Mr. Justice Lee held that the prosecution evidence was so weak, insofar as the fraud charge, there were evidence against dishonesty. And insofar as the collusion charge, it seems more consistent that he is expressing his view rather than inviting interference of foreign governments. And on that basis, the court decided to grant bail, but subject to very stringent conditions. Effectively, he was put under house arrest. The prosecution appeal, the case reached the Court of Final Appeal, the Court of Final Appeal make a general observation that it has no jurisdiction to challenge the constitutionality of any act or decision of the MPC or MPC Standing Committee. The statement was true insofar as interpretation by the MPC Standing Committee, but whether that should go further to cover any decision of the MPCSC remains a controversial issue, but the court made a categorical statement of that. It accepts that Article 42 should be given a meaning and effect compatible with fundamental rights and freedoms in Article 4 and 5, but it disagrees with the Court of First Instance regarding the acts endangering national security, and the court held is not confined to NSL offense, but could include any other offenses endangering national security. As far as the bail provision is concerned, the court found that Article 42 reversed the common law presumption of bail, and without much discussions of how this conclusion could be reached in light of Article 4 and 5. And the court adopted a two-stage approach. And under the two-stage approach, in the first stage, the court will have to consider the sole question whether the defendant will not commit any further national security offense while on bail. If the court is not satisfied and there's no sufficient reason to believe that the defendant will not do so, bail shall be denied. Only after the defendant can pass through this first stage, other conventional factors like the risk of absconding would be considered at the second stage. If we look at the provisions again, I've already shown the Article 42, which was framed in a double negative. So the Court of First Instance in Tong Yin Kit is to turn the double negative into a positive statement so that bail shall be granted unless the court has sufficient reason to believe the defendant will continue to commit acts endangering national security. And this substantially cut down the damaging scope of the provisions. The Court of Final Appeal said that was a wrong interpretation, and instead it changed the interpretation to become bail shall be granted only when the judge is satisfied defendant will not continue to commit acts endangering national security. Objectively speaking, both versions, the versions by the Court of First Instance and the Court of Final Appeal, could be supported linguistically. The double negative formulation is sufficiently ambiguous that it could be construed either way. But in such case, should the court not be guided then by the values underlying bail regime and the fundamental rights and adopt an interpretation that causes least restrictions on fundamental rights? Instead, the Court of Final Appeal adopt that two-stage approach and requires satisfactions of a negative state of affairs. Defendant will not commit any further acts, which is extremely difficult to satisfy. And the two-stage approach also ignores other important factors in the first stage. So why should bail be denied when there's only a tenuous evidential basis for the criminal charges? And why should the court be concerned with continuing commitment or commission of further offense, which is speculative, when the very offenses that he's charged has only a flimsy evidential basis? The effect of the judgment of the Court of Final Appeal is set a very high threshold and lead to the likelihood of lengthy pretrial detention. And that serves as a powerful deterrent and silencing effect when an accused could be deprived of their physical liberty, their employment, their family, their social life, while confining to years of unpleasant jail conditions, and will suffer devastating harm regardless of the eventual outcome of the case. It also encouraged police practice of premature or arbitrary arrests. It doesn't matter the defendant or suspect will be sufficiently punished by spending months and years of imprisonment, even if they are eventually vindicated by the courts. Jimmy Lai was put back to custody after the case, and he's still in custody. And it gives rise to concern about prolonged pretrial detention, which is aggravated by the problem of designated judges and premature prosecutions. This happened in another high-profile case, commonly known as the primaries or the 35 plus cases. And 53 opposition lawmakers and activists were arrested for taking part in an unofficial primary election in preparing for the legislative elections. And some of the plans was to win the majority of seats, over 35 seats in the 70 seats then legislature, so that they can force through some political demands, including boycotting and not supporting the budget. And that was regarded as a subversive plot to paralyze the government. They were far away from that. Yeah. And eventually 47 were charged. And since they will have to be tried, the bail application has to be heard by a designated judge. The bail application lasts for 4 days. And on the first day, the hearing ran to 3 a.m. in the morning, ending with at least 4 defendants to be taken away by ambulances. And among them, Benny Tai, my colleagues at Hong Kong U, he had to run between 2 courts to attend his appeal in Occupy Central before the Court of Appeal and the bail application before the Magistrate Court at the same time. And certainly Hong Kong court would be able or should be able to do much better than that. And the prosecution was not ready and the case was adjourned for many times. And that gives rise to a worrying practice of charging the defendants when prosecution was not ready to proceed at all. Now, this is not uncommon in criminal trial, but then the injustice is mitigated by the presumption of bail, whereas in this case, the reverse is true. And once they are charged, they have to be remanded in custody. And these defendants, most of them were denied bail. They have been detained for over a year now, and there's still no sign when the trial will take place. And indeed, the trial, it has been decided that the case would be referred to the High Court today, but then the transfer was adjourned to next week because of the COVID. And delay was further aggravated because of the designated judges system. So the aftermath is that bail was denied in an overwhelming majority of cases, and it is difficult to discern any consistent principle on when bail would be granted. And some were denied on rather tenuous evidence. For example, one of the former legislators was denied bail because he received invitations from foreign consulate, even he did not respond and did not answer to the invitations. But the court took it as evidence that he has the ability to collude with foreign governments, and therefore he should be denied bail. Article 42 has also been extended to non-NSL cases, and the government has adopted an extremely broad interpretation of what constitute national security offenses. And in Tam Tak Chi, another case, the defendant was charged with uttering seditious words under the crimes ordinance, set to bring into hatred and contempt of the government, raising discontent and dissatisfaction amongst the people of Hong Kong, which is extremely broad. And the court applied the NSL principle, including that he should be tried by a designated judge, and the principle of bail in Article 42 apply, even though he was not charged with an NSL offense under the NSL. The verdict was supposed to be delivered last week. It was adjourned to later this week. And he, among his defense, he raised the Bill of Rights defense and argued that this arcade criminal offense of seditious propagation is inconsistent with the guarantee of freedom of expressions. And it will be interesting to see how the court is going to decide the case later this week. The application of Article 42 to non-NSL cases has been challenged in another case, and which eventually they apply for leave to appeal to the Court of Final Appeal, but the Court of Final Appeal refused to grant leave and refused to review the bail principles that it laid down in Lai Chi-ying, the Jimmy Lai case, notwithstanding that now there are plenty of evidence that a large number of defendants has been denied bail because of the bail principles as the Court of Final Appeal laid down in the Jimmy Lai case. The Court of Final Appeal said, viewed purposefully, the intent of NSL is plainly for national security to be safeguarded by the application of other laws. And the NSL is intended to supplement local laws Hence, Article 42 is applicable to seditious publication under the Crimes Ordinance. And the court conclude that no reasonably arguable basis for the proposition that the more stringent threshold for the grant of bail is confined to the offense created by the NSL. But when fundamental rights, such as personal liberty, are restricted, Parliament will generally be presumed not to intend such effect without express wordings or necessary implications. But the well-known principle of legality will speak for why the national security offense or the bail principle in national security offense should just be extended to other criminal offense in other statutes. The fact that NSL prevails over other inconsistent law is not the same as filling the gap of other laws by inserting NSL requirements. It will also create a lot of uncertainty as to what offenses will attract the more stringent bail principles, whether it will endanger, whether it's a national security offense depends a lot on the alleged facts supporting the offenses. The only consolation is that the Court of Final Appeal calls for more vigilant case management to avoid prolonged pretrial detention, and it still remains to be seen how this reminder from the Court of Final Appeal is to be implemented. Turning to another aspect of jury trial, one may recall that the NSL allows the Secretary for Justice to issue certificate to direct a trial without jury on various grounds. And in Tong Yin Kit, the SJ issues such a certificate without setting out any factual grounds for the belief that it is necessary for the protection of the juries and their family members. At first instance, the Court of First Instance reject that there is a right to jury trial at the High Court because once it is in the High Court, the defendant has no right to waive jury trial. And secondly, the court has power to transfer the case back to the district court where there is no jury trial. Both grounds are unconvincing. On the first ground, the fact that you cannot waive the right not to be tortured doesn't mean you don't have the right to not to be tortured. And on the second grounds, the fact that the court decided to transfer the case back to district court after due process and after hearing the parties simply means the right to jury trial is not an absolute right, it can be restricted. But it doesn't mean the right does not exist in the first place. When it goes to the Court of Appeal, the Court of Appeal relegates and downgrade jury trial as nothing more than a choice of venue of the trial, and a requirement of jury trial refers only to the mode of criminal trial that must be adopted at the Court of First Instance, but it doesn't necessarily entails a right of the accused, despite volumes and almost decades, if not centuries, of case law highlighting the importance of this important safeguard. The Court of Appeal readily accepts that Article 46 just creates another mode of trial at the High Court without jury. And apparently, the Court of Appeal was affected by the concession that there's no question that the defendant's right to fair trial is compromised by the alternative mode of trial by 3 judges of the High Court. But with respect, this argument missed the point. Jury trial is not just there to ensure a fair trial, but more importantly, it is to instill a sense of public judgment of what is right and wrong in the criminal justice system, which is of particular significance in a political trial, and especially in a case like this when it turns on the meaning of a slogan. And as far as the certificate, the court adopted a differential approach and held that in the absence of any allegation of bad faith and dishonesty, the court will defer to the Secretary for Justice and will not go behind the certificate, even though no factual evidence was set out to support the reason for applying the certificate. Another worrying aspect of the Court of Appeal's judgment is that the Court of Appeal regard the NSL as a statute with a constitutional status, and therefore it should be given a purposive and contextual constructions. And this purposive approach is to give full effect to the primary purpose of the NSL. the broad and purposive approach is to be given to the interpretation of rights that is well established. But by any standard, the NSL is a criminal offense, a criminal statute creating criminal offenses restricting fundamental rights. But by a twist of logic, the Court of Appeal now apply the broad and purposive approach not to the constructions of right, but to the construction of the restrictions of right, and hence broadly expand the scope of the restrictions. Now we come to the Tong Yin Kit case. This gentleman is Tong Yin Kit, the defendant, the first NSL case. The case against him was he rode a motorbike with a flag protruding on which the slogan, "Liberate Hong Kong, Revolution of Our Times," was set out there. And he rode along the street on 1st of July when some police officers tried to stop him. He tried to avoid them, and eventually he ran into some of the police officers and injured them. The facts were largely uncontested, and he was charged with 3 offenses: incitement to secession and committing a terrorist act with an alternative charge of dangerous driving, which seems to be the only most credible of the offenses. And the case turns on the meaning of the slogan, "Liberate Hong Kong, Revolution of Our Times." The prosecution tendered expert evidence, so did the defense. But this is puzzling. The charge is incitement, inciting the public to secession. And if the incitement could only be understood by the expert, how could the public be incited? And if the incitement is readily understood by the expert, then this is a particularly suitable case for jury trial. And why exclude jury then? In any event, experts on both sides disagreed on the meaning of the slogan. The court managed to extract a minimal agreement that the slogan was capable of carrying a secessionist meaning. And on that basis, Tong was convicted. But whether the slogan carried a secessionist meaning must go to the element of the offense. And if it is capable of carrying a secessionist meaning, it must be capable of not carrying a secessionist meaning. And how could this standard be compatible with presumption of innocence and proof beyond reasonable doubt, let alone the right to freedom of expressions? And looking at that slogan, which is terribly vague, what exactly was the public incited to do then? The court finds that it is unnecessary to answer these questions. And as far as the terrorist act is concerned, the court finds that it is a serious challenge to the police. It would instill a sense of fear among law-abiding members, and that could lead to a breakdown of law and order and would therefore cause grave harm to society. Seems to be entirely out of context of the facts of that case. And in order to be a terrorist act, should the harm reach a certain level of severity, affecting a sufficiently significant number of the public in order to constitute a terrorist act? In any event, for that act, Tong was sentenced to 9 years imprisonment, and he has abandoned his appeal since then. The second case is known as the Captain America case. As you can see, the defendant is carrying a shield of Captain America, and he was a usual participant in all kinds of street demonstrations, etc. And unlike the Tong case, this case involved no violence at all. The case against him was he distributed leaflets and chanting slogans, and in most cases he was ignored. But the court said whether he used violence, whether he defiled the law enforcer, whether his ideas got any others recognitions, these are not important. He was charged with incitement, and incitement is completed as long as one can prove that the slogans have secessionist meaning and he has the intent to do so. It seems that he was punished simply for expressing his political belief in public. And there's no proportionality analysis at all. The court made no reference to Article 4 and 5 or any fundamental rights at all. Moving outside NSL, we have seen also the court has adopted a very tightened approach to the right to peaceful assembly. In one of the most notable case involving some of the well-known figures, Martin Lee, the most senior members of the bar and known as the father of democracy, and Margaret Ng, the legislator for 18 years, who was the representative of the legal functional constituency. They were charged with organizing and participating in an unauthorized assembly. And the interesting thing is the prosecution accepted that an unauthorized assembly was entirely peaceful from beginning to end. And the only evidence of organizing was that they carried a banner in front of the demonstrations that seems to be sufficient for participation, but far from organizing. And they were convicted, and the court said that taking into account the then political atmosphere, that an unauthorized assembly would carry the propensity to become violent. And for that, the court adopted 18 months imprisonment as a starting point. And most of the defendants were convicted with sentence between 8 to 18 months, including the 3 lawyers who were given a suspended sentence of 2 years. And Margaret Ng delivered very powerful mitigations in person at the end of her trial. And she said it is not in dispute even by the prosecution that the event was entirely peaceful and orderly without any untoward event. The crowd has kept faith with the organizer, who enjoined them to be peaceful, rational, and non-violent. When the people in the last resort had to give collective expression to their anguish and urged the government to respond, protected only by their expectation that the government will respect their rights, I must be prepared to stand with them, stand by them, and stand up for them in the hope that peace may prevail. And he quotes from Sir Thomas More with adaptation and becomes a well-known statement: I stand the law's good servant, but the people's first, for the law must serve the people, not the people the law. Other important events include the banning of the June 4th candlelight vigil cases. And this has long been a symbol of freedom for Hong Kong, as Hong Kong is the only place on the mainland where June 4th commemoration is allowed. But for 2 consecutive years, the governments, the police did object to the holding of the peaceful assembly on COVID grounds, despite other mass events are allowed to proceed. And the organizer who organized the event in June 2020 were convicted of incitement and organizing an unauthorized assembly. And in 2021, Zhao Hangtong, the lady at the below, a barrister and a Cambridge graduate, after the proposed June 4th events were not authorized by the police, she posted 2 posts on social media, which the court construed as capable of inciting other people to join her to participate in an unauthorized assembly. And for the 2 posts, she was convicted and sentenced to 15 months imprisonment, with 8 months concurrent with the previous charge. So altogether 22 months imprisonment for organizing a peaceful assembly and inciting, so-called inciting. Indeed, in June 2021, no assembly were turned out eventually. I won't have time to go to the electoral systems. Suffice just to say that the electoral system has since been reformed to significantly water down the democratic element. And the principles now is only patriots can participate in elections. And oath of allegiance has been adopted as a criteria to assess candidates for standing for election, as well as for continuance in elected public offices, to ensure this principle that only patriots can administer Hong Kong. Many candidates have been excluded, disqualified from standing, and serving members has been disqualified. And this oath requirement is extended to civil servants as well as judges now. So where does that leave us? Some people who support NSL would say law and order have since been restored and business as usual. And to some extent, this is true. The question is what price to achieve that. It's also undisputed that a large number of arrests and prosecution of political activists and dissidents with prolonged pre-trial detention. Most of the offense were related to public statements, political stance, or other political activities. At least 14 were arrested over financial activities, including crowdfunding campaign to support young protesters to move to Taiwan or to support the legal costs for their defense. Peaceful assemblies were punished with heavy sentence. Media organizations were raided, had their access frozen, editors and management arrested, and eventually have to close down. Over 80 civil groups, human rights organizations, even professional unions have to disband themselves or relocate elsewhere, one after the others. And there's mandatory requirement of introduction of national security educations for schools and universities. And also the police has set up a hotline dedicated to NSL offense. And according to police figures, by November last year, they have received over 200,000 tip-off messages, which allow anonymous complaint of alleged violation of NSL offenses, and including mainland Chinese students complaining, an assistant professor for what he said in class. Academics at Hong Kong USTs were accused of receiving funds from US government to recruit students to participate in a public demonstration as part of her research. And more recently, one of my colleagues in social science at Hong Kong U were criticized for appearing as an expert witness for the defendant in the first NSL cases. That led to Professor Jerome Cohen, a well-known sinologist for over half a century, to conclude that the risk of criminal punishment has made many people afraid to express themselves. People now in fear want to avoid arbitrary punishments. This is a challenging time for the judiciary and the rule of law. I readily accept that national security is a legitimate aim for restricting fundamental rights. And it is not just a concern of Hong Kong. National security is a common concern almost in every jurisdiction. But the question is whether NSL has swung the pendulum too far. And a legitimate aim is only the beginning and not the end of a proportionality inquiry. And Article 4 and 5 of the NSL are there, and the obvious reason for them to be in the NSL are to mitigate the effect of the sweeping offenses. But has the judiciary given them the proper prominence that they deserve? In 2005, the Court of Final Appeal said in the Leung Kwok Hong case that in a society governed by the rule of law, the court must be vigilant in the protection of fundamental rights and must rigorously examine any restrictions that may be placed on them. That goes to the core of the rule of law. 17 years later, under the NSL, the court seems to have adopted a differential approach to the interpretation of the NSL and adopt a rather low standard of scrutiny of NSL offenses. Would there be room for judiciary to respond in another way to this sweeping offense? I asked a number of questions. Is it not possible for the CFA to hold that bail shall only be denied when the court is affirmatively satisfied that the defendant is likely to commit national security offense while on bail? Is it not possible for the court to say that if jury trial is to be excluded, the Secretary for Justice shall provide at least some factual evidence in support, and if necessary, to adopt the special advocate procedure if the information is too sensitive? Is it too much for the court to require an obvious, necessary, and reasonable meaning before words can be found to amount to an incitement, or the existence of a sufficiently proximate link between an act of incitement with the national security offense to be incited, when the offense could carry substantial or even life imprisonment? And is it not possible for the court to require the existence of a real risk of a grave and serious danger to community before an act could be attributed as a terrorist act or national security offenses? And none of these is excluded by the NSL, at least on paper. The rich tapestry of common law principles are there to allow the court to strike a better balance, without sacrificing the importance of protecting national security. Judicial independence requires not only that the court acts independently, but also that the court is seen to be acting independently. Public confidence in judicial independence is very much part of judicial independence. It is a lingering question if judicial independence could be maintained when there's no civil society and when the public loses confidence in judicial independence. In adopting an excessively differential approach, the court may be providing rationalization and intellectual justifications for an authoritarian regime. And contemporary academic studies shows that there could be different judicial responses, even in authoritarian or semi-authoritarian regimes. Court could be innovative and responsive in invoking various common law principles to mitigate the severe and drastic effect of a repressive regime, or courts could be abusive and go along and become part of the repressive regimes. Which way are we going? Only time will tell. Thank you.
Thank you so much, Johannes. There's so much there, such a very wide-ranging lecture, extremely thoughtful. And I know that you've written a paper, or you're in the process of writing a paper, and I would absolutely recommend it to other people. We're a little bit short of time, but I do want to give Jeff King the opportunity to comment. I've also picked up, we've got about half a dozen questions that have been put in the Q&A, actually slightly more, but I'd like to hear from Jeff, who's got some comments he'd like to raise, or some questions for you, Johannes. So Jeff, do please go ahead.
Thank you. I'm sorry, my son has walked in the room. That's fantastic. Could you just give me one moment, please?
Excellent timing. It's usually the point at which somebody bangs on the door, actually, when people are working. I'm sure he'll be back in a moment.
Sure.
And we'll keep going for a little while longer, because I know that Jeff wants to make his comments, and it might be possible to answer one or two of the questions I've actually picked up about 9 questions. Jeff is back. Great timing there, Jeff.
I did my best to avoid that, but I'll be very quick. That's an extraordinary lecture, Johannes, and I just wanted to raise a few questions, but I wanted to also begin by saying that it's incredible and startling how quick the decline of respect for rights in the Special Administrative Region of Hong Kong has been. So let me just begin with my questions to you, which perhaps you can answer in the course of the discussion where you address the other questions. That's for you and Hazel to decide. Firstly, I wanted to ask whether the central government has violated, in your opinion, the terms of the Sino-British Joint Declaration by departing from the provisions of the Hong Kong Basic Law in the way that they have, or is there an argument to be made there that would make this a bigger diplomatic issue for the UK than it currently is or might be? The second question concerns the role of legal argumentation in the dispute between lawyers and politicians in Hong Kong and those that the authorities in the central government. How much does legal argumentation actually matter in dealing with central government? I see you've discharged a number of arguments that were offered by the central government for the national security law based on Article 23 of the Hong Kong Basic Law, that Hong Kong is required to provide an environment in which the national security of the mainland government also is protected. And you say that this argument isn't justified by the facts on the ground. There is a robust regime of protecting national security, and many prosecutions have taken place under the existing law. The national security law wasn't required. Does that kind of argument matter, do you think, to Beijing, to engage in that legal way? Or are you showing in your article and your presentation that simply that the legal case for the national security law is something of a pretext rather than a genuine legal argument? The second question is about the idea of the rule of law with socialist characteristics, which is a subject of a a discussion in the International Journal of Constitutional Law just now, and Jerome Cohen is one of those contributors. It's observed in that discussion that China is something of a rule by law state, not rule of law, but rule by law. I wanted to query whether that's even an accurate description. Is it even a rule by law state? Because it seems that a lot of the provisions that are discussed are not, in a sense, they're not really applying law at all. They're applying sovereign will, sovereign force, but that the people that are subject to those rules don't have the benefit, the ability to argue that the terms of those rules have been enforced in a legally correct way. There's no way at all to show that, as far as I can tell, under the national security law for the reasons you've given. So the fact that the chief executive can designate the judges for a year at a time, cases can be removed to the mainland courts, the certification of facts as being acts of state and then cannot be challenged in the courts. All of these elements essentially mean that one isn't even in a position to insist that the authoritarian rules, given whatever their content may be, are actually applied faithfully to these people. And so it's not even a rule by law situation, as far as I can tell. The second set of questions I wanted to put to you is about strategy of political and legal resistance or pushback. There's a discussion in law, constitutional law and legal theory, about so-called judicial restraint on prudential grounds. And I wondered whether you think it's possible that the judiciary in Hong Kong is to some extent trying to keep its powder dry to preserve their own institutional continuity, not necessarily just to save their own skin, but to try to maintain at least the shell of a proper justice system by allowing the central government policy to be implemented in the way that it wants. Are they playing a long game, in other words? Now, I instinctively I am critical and have been critical of this argument for judicial restraint, because I feel like it, based on prudential grounds, it feels like judges turning their backs on the law. But some probably would argue for this kind of deference as a way of maintaining at least a minimum of the rule of law in the long run. And I'm curious to know what you make of that argument. And similarly, for the political protest, in the account you gave, the protests over the Extradition Bill were seen as something of a turning point by the mainland authorities because they were boisterous. And I wondered whether some are arguing that there could have been a different type of strategy, something of a long game, where these freedoms were exercised more slowly in order to preserve something. Do you think that really would just prolong the inevitable, or even just allow the central government to take complete control in a very insidious way without any protest? Or do you think there might be some argument that a slower form of resistance might have been indicated in this context? That's all that I wanted to ask you.
Right. There's quite a number of questions, and I don't pretend I will be able to answer all of them. I try to address some of them. For example, as far as the violation of the joint declarations, it boils down, as far as the joint declaration certainly promised the protection of various fundamental rights. And we can see that the NSL, in a way, arguably have not achieved a proportionate balance between those fundamental rights that were protected and national security. The difficult issue is the prime issues is whether the JD could be enforced at all. The Chinese view is that the joint declaration is spent upon the change of sovereignty. So therefore, it is no longer an enforceable treaty as such. And all the promises are only Chinese policy. That goes to the very nature of the joint declaration. And I find that a bit disingenuous because taking Chinese governments to the extreme then, their idea is the joint declaration is nothing more than an agreement to return Hong Kong to China. And once returned, that is the end of the joint declaration and nothing else is relevant. If that is the case, it is unnecessary to spend 2 years in negotiating what are the policy of China towards Hong Kong after the change. And taking that argument to its logical extreme, China could then say on 1st of July 1997, thank you very much, I got back Hong Kong now, I'm going to tear the documents and you forget everything I promised. Now, that could not be a good faith interpretation of an international treaty. So I don't think it's sound. I think the joint declaration at least valid for 50 years, but how could it be enforced? Because it doesn't include any enforcement mechanism. That leaves a number of questions of how it could be enforced, but at least as far as its validity is concerned, I don't find the Chinese arguments convincing on that. Secondly, the pretext for enacting the NSL is always on the basis that Hong Kong has failed to enact its own national security law, and Article 23 expressly states that Hong Kong should enact law on its own. And if we go to the drafting history, it is clearly that provision is deliberate, that Hong Kong people in the 1980s were still very concerned about the anti-revolutionary law on the mainland, and noting that this area of national security could easily come within the area of defense and foreign affairs, and therefore outside the jurisdiction of Hong Kong. So Article 23 was expressly put there to allay the worry that Chinese national security law, counter-revolutionary law will not apply. This is still an area within the domestic autonomy, and it is for Hong Kong to draft its own law so that it can take care of its traditions and values of the rule of law. So whether one call it a delegation or irrevocable delegation, at least the law is binding. Article 23 is binding that the primary obligation is on Hong Kong to draft the law. And the argument is, but Hong Kong has failed to honor that obligations. And I find it strange in the sense that we have all the laws protecting Her Majesty government before 1997, and most of these laws are retained. But on the 1st of July, we have a modifications, a reunification rule, which change all the references to Her Majesty, the governments become Central People's Government, or the Hong Kong SAR as appropriate. So in one stroke, we basically turn all these pre-existing law into the law protecting the national security of the new regime. It may not be a very elegant way of doing that, and the government has failed to amend to put the amendment in the consolidated versions of the old law. So if anyone goes to the old law, you will still find the reference to Her Majesty there. But this has already been changed wholesale by a reunification ordinance that were passed on the 1st of July, 1997. Therefore, the arguments cannot be Hong Kong is in breach of its constitutional duty, and indeed the recent resort to offenses like seditious publications shows that they are still valid and effective. And if the argument is Hong Kong law has not gone far enough, that is a completely different question, and you could not on that basis justify an enactment by the PRC law for Hong Kong on that ground. And as far as the socialist rule of law, I think this raises a much broader questions of what is the rule of law. And I tend to share with your agreement, with your point that whether China's is a rule, even a rule by law, and their conception of rule by law or rule of law is basically there are laws there to govern the system. But then how the law is going to be implemented is a million-dollar questions in China. Everyone who studies Chinese law will know that they cannot just look at the law. They need to know the actual implementation, which could be completely different from what the law said. And every now and then there are a lot of gaps which allows subjective interpretation. And even at the highest level, the MPC Standing Committee, as a legislative body, it can enact law, it can interpret law, and it interpret the law it could interpret the law in a way to amend the gap of the law, making the distinction between interpretation and amendment very thin. And in the process of amendment, unlike a rule of law system where a court or even government officials are constrained by the language of the law, in Chinese traditions, language is served only as a pretext, and it seldom served as a constraint or restraint of the governing regime. And in interpreting the law, objective factors, I can't deny that there are objective factors, but at the same time, political consideration, political expediency, they all comes together in the interpretation of law, and law basically is regarded as an instrument to achieve certain policies. As far as the political pushback, I'm sure that is one of the arguments, and that it is better to preserve the institution of the court than to run into full conflict with the sovereign countries, and that would cause greater loss of the rule of law. The difficulty, one, is how far do you have to exercise these prudential grounds, and up to what point it becomes unacceptable. It is difficult, and once you start conceding on certain things, it is difficult to go back. And secondly is whether it would work at all. No one really knows. And would the concessions be regarded as enough, or whether the concession means that you are compliant and they would demand more. And so it is difficult to say, and I'm sure that at least some people in Hong Kong think that is a better way, so that even if we don't have much freedoms in the political side, at least we can achieve the rule of law in the commercial side. In this regard, Singapore has always been a model that all we need is commercial side. The two, especially for an international center, cannot be easily disentangled in reality. The last question is also a very highly controversial and almost an emotional debate among people in Hong Kong. Looking back in the last few years, there are always questions. If the protest has not taken the more violent form, would things be changed, etc. We could all learn, could all be more wiser after the event. The difficulty is we do not know, had this not been done, what would have happened? And history does not allow us to do a comparison on that, and it would probably be unfair in a way, and indeed recently an academics has blamed some protesters that they have sacrificed 30 years of struggle for democracy simply because they act too aggressively. And that has attracted widespread criticisms. And whether, again, whether slower resistance would work, whether the recent event is only a triggering factor, and one should not assume that it is all what has happened in Hong Kong that changes the policy. China has also been changing, and one obvious change that I can discern is back in the 1980s or even in the early 2000s, China has full respect for the management and the rule of law in Hong Kong, in that this is something new to them. They don't have the expertise how to run a sophisticated metropolis financial center in the world. By 2010, China's changed the tone very differently. We can run Shanghai, we can run Hong Kong. So the socio-economic development has changed, and that affects China, especially when one country, two system rests entirely on self-restraint. And as China becomes more confident, more economically powerful, she becomes also less tolerant of a completely different systems in Hong Kong. And they would have thought that if things work in China, it would work in Hong Kong, and why should we tolerate a different way of working, etc. So I think that there are multiple factors there which leads to the present day policy, and it might be unfair or just to attribute it to one factor that had we not been too aggressive, things will change. No one knows really.
Can I say that both the questions and the answers have been absolutely fascinating. I'm aware that we're quite a long time over time. I wanted to say that actually our audience has been very engaged, and we've got about 15 questions here, but I don't think we've got time to answer them, and I've just checked. And I think if it's okay with you, Johannes, what we'd like to do is to collect together the questions. They can all be collected anonymously,
Right.
and perhaps you could look at them and provide answers to some of them. And Kat, who's our organizer this evening, has said that they can be emailed to all participants, to everybody who's tuned in this evening. If that would be okay with you, because some of these questions are really very interesting,
Right.
but are going to take quite a long time to answer.
Right.
And it will give you time to think about it, and also give people an opportunity to have that sort of thoughtful response rather than a kind of off the cuff one. So if that's okay. And what I want to do is to thank everyone who's submitted questions, and they're not being ignored. It's just a sort of a time issue, and we will collect them together anonymously, and Johannes will have a look at them, and then we can send the responses so everybody can see the questions, which I think will be absolutely fascinating. So we're kind of continuing the conversation. But at this point, what I want to do is to thank Jeff for your extremely thoughtful questions, incredibly thought-provoking, and well done to Johannes for dealing with those off the cuff. But particularly to thank Johannes for a really inspiring lecture, really thoughtful, very, very well documented, raises so many questions that we could go on discussing this forever. But anyway, thank you very much indeed, and thank you to everybody who's attended, and I hope that you found it as fascinating as I have. So thank you very much, and with that I think we will leave. I don't think we can't do a round of applause because nobody has their microphones up, but
Thank you.
Thank you, Johannes, lovely to see you, and thank you very much for a wonderful lecture. Bye-bye, everybody.